My Lord, I won't be quite the last speaker. Mr. Willis is going to deal with one issue after me. So close, but quite not there. My Lord, I'm going to start with the issue of mootness because my learned colleague for the
Everybody
minister...
wants to do mootness. Anyway,
Yes.
Yeah.
My Lord, I will come to the questions that you've debated because, to be honest, I think the mootness issue is easier and I'd like to get it out of the way. My Lord, if we take a step back, and your Lordship referred to Bishop Desmond Tutu during the bad old days of apartheid. My Lord, one of the issues there was that we had a parliamentary supremacy. In other words, we had a unipolar state. In other words, the Parliament could do what we like. We moved to a situation where we had constitutional supremacy, and that set up the separation of powers, the judiciary, the parliament, and the executive. My Lord, with the triggering of the DMA, we went down to a bipolar state. In other words, the parliament had no say in the regulations and were not able, in terms of that statute, to oversee the executive in any sort of way. So what we are left with is judicial review of the executive's actions. Now, if we look at this particular case and how it's been pursued by the minister, what have they done? They've come here and they've argued mootness for most of the argument and then barely dealt with the regulations. And my Lord, I'm going to put it to you that this is a pattern, and I'll show it to you, and the effect of it. And if your Lordship accepts that this matter is moot, what we will have is an executive without any form of check or balance, which is the very essence of the separation of powers. So let's look at what happened. My learned colleague for the minister said, well, this was a very short period. But my Lord, it was traditionally, my Lord, the president addressed us on a Sunday night. On Monday, the 1st of February, he changed the regulations and reopened churches. And we were in church, in court. Pardon me, my Lord. Maybe a Freudian slip there, but we were. My Lord, I'm not confessing to any sort of crime, but
Yes.
Be that as it may, my Lord, we were in court the next morning to seek an order that those regulations were unconstitutional. So literally on the court's doorstep, the regulations are changed. If we go back to the Liberty Fighters matter, one of the reasons that case became so problematic, and that's apparent from paragraph 3 of His Lordship Davis's judgment, is that while they were arguing the matter, the regulations changed. And here again, and there's a case I would like to refer your Lordship to, is the sorry, I'm just scrolling up. The Skole Ondersteuningssentrum NPC, Bronkhieland Kleuterschool, and Solidarity, case number 24258 of 2020. My Lord, it has been uploaded onto case lines, but I want to refer your Lordship, and maybe I'll see if I can share the matter. Yeah, this is the submission.
65D3. The 65D3 is a point of law, isn't it?
Yes, it was delivered in terms of that. It was a notice delivered, but I want to.
That's the equivalent of a point in limine in an action proceedings.
Yes, and basically what the regulations have changed. This is a submission from an amicus curiae. So The first and third respondents, these were ministers for the sole purpose of disarming the court from adjudicating over the matter at the very last minute, and thereby leaving the applicants without legal recourse, without warning or notice. And then, my lord, further down, I'm going to take you, pardon me for my scrolling, I think I'm in the paragraph 48. Pardon me, I'm just finding the spot. And here again, it is at paragraph 28, it's very evident from this latest circular issued and distributed that the administrative actions of the third respondent, and by implication the first respondent who's simply following a lead, are an ever-moving target. My lord, that is, with respect, that is the point that I'm trying to make, is that if your lordship is not inclined to deal with this, with these regulations, then no one ever can. No one will ever be able to scrutinize the actions of the executive.
I mean, you basically, for me to come to that conclusion, I have to accept that there's a mala fide on the part of the minister and or the cabinet or whoever by amending the regulations on the eve, as Advocate Engelbrecht pointed out, on the eve of the hearing.
My lord, if I may.
On what basis? Because it's ever-moving target, it's tendency.
Yeah.
They'll do it all the time. We'll never hear their case. Because
Yes.
if maybe we have to come to court, they'll change it tomorrow. Well, someone does that with putting water back. Someone does it with returning of a child. All you do is mulct them with costs.
My lord, but this is, to be honest, this is much more important than any of these because it's the restriction of a constitutional right. So if we look at the AfriForum case, both Collipin J and the SCA grasped the nettle of dealing with these matters because they understood that it's important for our democracy that there be proper scrutiny of the executive. If the parliament can't do it because they're disqualified by the act, then it has to be the court, my lord. So I'm not asking you to find.
The point is the court only deals with live issues based on, and it will allow the matter to continue. The factual matrix is the same. Now, are we changing that law then? Are we now changing the law on mootness?
My lord?
If we're doing so, then I think we're also duty-bound to say we're now looking at mootness differently.
My lord, even my learned colleague for the minister admitted that you can hear this matter on the interests of justice. His argument is that you shouldn't. So your lordship is entitled to deal with this matter. And my argument is that the only matters that have actually been dealt with are those where the courts have agreed to hear the matter on the interests of justice. If not, they're elusive, they disappear, the regulations change. And I think it's very, very important when the executive is unilaterally limiting the rights of constitutional rights of people that it be subject to scrutiny. Now, my lord, if we look at the conduct of this matter from the beginning, we started with a morning-long argument about whether affidavits should be admitted or not. Eventually, in order to force this matter to go ahead, my client or we withdrew both our affidavits, my lord, and that goes to show that my lord, there seems to be a stratagem, and it's evident from our learned colleague the way he argued the matter that he's trying to avoid the scrutiny that comes if on the actual matter itself, the merits of the matter. So they've taken a procedural issue. They take it again and again. I accept that. But my Lord, the bottom line is, if we ever want to know whether this is constitutional or not, whether it's appropriate or not, the only place we can get redress, and our 14 or 11 million people we represent, is if the court grasps the nettle, as they've done in Esau, in AfriForum, where courts, and my Lord, I would argue that considering that the SCA has twice grasped the nettle, that your Lordship is, if anything, bound by that as well. The bottom line is that this is...
No, there's no ratio decidendi there. There's just a decision taken by them saying, in our case, we want to do so. There's no ratio decidendi that arises from that on this point.
My Lord, I would submit that if, as an Augusta court as the SCA grasped the nettle, that it's important that other courts do too. It's in the interest of justice. My Lord, we live...
Yeah, I can see the persuasiveness of the point, but I can't see the stare decisis of the point.
My Lord, then maybe I misspoke. I certainly meant the persuasiveness.
Yes. No, so I thought I'm bound by it.
No. I apologize. I concede, my Lord, I should have used the word persuasive, but I would argue that it's very persuasive, that there are two matters. Let's take the AfriForum matter. All that money was paid out already. If ever there was a matter where an argument for mootness could be made, surely that would be it. The money's gone. They all say the money, we don't expect you to change anything, take money out, but it's in the interests of justice that these decisions be made and dealt with. And I would argue that the SCA has done that twice, and that should be of tremendous persuasiveness to your Lordship, because these are important issues. These are constitutional issues that where millions of people's constitutional rights are limited, and without the courts we have no scrutiny. So I would argue that you don't need to find that they're trying to duck and dive. I would argue that all you need to do is accept that since the religious, if we look at it, the religious freedom rights have been limited, and that just on that there should be scrutiny. The only scrutiny is going to come from your Lordship, nowhere else. And
so what does it do to the law on mootness?
My Lord, I would suggest it keeps it exactly the same, because the SCA has twice now agreed to step in, and so whatever that the SCA felt it appropriate to act suggests that is the law, or certainly that should be the approach of courts.
Okay.
My Lord, so I would argue that the minister's argument on mootness is a non-starter. I would argue that this is an extremely important matter, that it's in the interest of justice that this matter be settled. And my Lord, without a decision here, we will never know whether this limitation was constitutional or not.
Is a mootness finding not appealable?
My Lord, but this would be appealable.
Yes, a mootness finding would be appealable.
Yes, it would be appealable, but my
final decision. It's not an interlocutory decision.
No. It's a final. It's a final order. Yes. So it would be appealable.
It would result in, as we asked Mr. Mokgakabe, what order will flow from there? The order will be that the applications are dismissed. Well, then that's final, isn't
it? My Lord, I would argue, in light of the interests here, and I'm going to add a further argument to this, is that in paragraph I think it's 5 of my learned colleague for the state's heads, he concedes that the RAS is still in place, the risk-adjusted strategy. So as of right now, there is a risk-adjusted strategy in place, that we still have a state of disaster, and the minister may still limit constitutional rights. And I think that the clincher here is that Mr. Mogagabe convinced me that this matter isn't moot. Because your lordship asked him, will the minister do this again? And he gave you a 3-part answer. And if he had just said no, the minister won't do this again, then we would be in serious trouble. But I listened very, very carefully, and he never said no. He said his 3 parts were a bit this, a bit that. And give him his due, my lord, he could easily have said no, and to his credit, he didn't. He danced like any good senior counsel should when they asked a question that is awkward. He never said no. If the minister was going to say, I accept, I'm never going to treat you differently to restaurants, to casinos, etc., that would be the end of the matter. So, my lord, unless there's anything more on mootness, may I move to the next point?
Yes.
Okay. My lord, the next point is the justification and the rationality of this matter. Now, my lord, if we look, and I'd like to use a hypothetical person here. If we look at someone who gets out of bed on a Monday and he gets into a taxi, and here, your lordship, I would like you to direct you to 001/103 of our papers. I believe it's at paragraph 11. And here we include an article where Professor Mahdi made it clear that the government's COVID taxi regulations allowing for 100% seating in taxis for so-called short trips cannot be backed up by science, and that it will do nothing to stop the spread of COVID. So, my lord, what we have is a situation here is we have a regulation that's in place at the time when no one is allowed to go to church. It will do nothing to stop COVID. In fact, to be frank, COVID is almost certainly to spread in taxis. That same man then goes to work all day, and then he goes to a restaurant, and he eats. He takes off his mask. Now, my lord, I've never seen anyone eat with their mask on. Everyone takes their mask off. Restaurant.
I'm going to wait for someone to do that.
My lord, I'd love to see it, and that's the point.
We should be the first to try it.
Yes, but the point is that would be the extreme exception. So then he goes home in a taxi. Then he gets into the taxi again, and he goes to work again. Then he goes to the casino. Then the following day, and he gets back into that taxi. He gets into the taxi, he goes to work, and he goes to gym, and he gets back into the taxi. And then he so on and so forth. But Sunday he stays home. But his father goes to church for an hour and a half, keeps his mask on the whole time, and never, ever, and keeps his social distancing. My lord, which would have the greatest spreader effect? And let's look at the actual effect of the regulations. The regulations as they stood.
I said this many times. The minister has not denied anything you people have said.
Yes.
So I'm forced to do it.
Yes, my lord. But
all the cases, she's never, the presentation of her being uber irrational doesn't make sense to me. Or
my lord,
require uber rationality from her. It's silly, not making sense to me. She's never denied all of these things.
My Lord, so let's...
Her case has never been that they don't spread. Her case has never been that they're safer than than churches. It has never been. That affidavit, look at it carefully. It's never been any of that.
My Lord, in fact, what she says is, she speaks about clapping and hugging, but my Lord, the bottom line is...
Yes, she does say that.
Yes, but that is her sole justification for closing churches. That is the long and the short of the papers that we do.
She has never said that there's no spread in the taxis, in the casinos, and in the restaurants. For some reason, the three groupings have all latched onto these restaurants, casinos, and nobody said about why does she allow the petrol attendants to go to work. Nobody has said why does she allow. For some reason, these three activities seems to have caused a great deal of consternation amongst the applicants. I don't know if they thought this was the weak link in the minister's regulations. But she's allowed all sorts of economic activities. Some where the spread the risk of spread is even higher than in I'm sure in casinos than in. For some reason, casinos seems to have a huge problem.
My Lord,
constantly being referred to in this case, in argument all the time.
My Lord, if I may suggest why that is. The reason is that under level 3, an adjusted level 3, in June and July last year, roughly, I forget the exact dates, churches and religious institutions were opened and those institutions were closed. Then in December, the minister reverses that position. She keeps them open, but she closes churches.
Okay.
And she never... Pardon?
So that's the reason.
So she and here's the key: is she never explains the rationale behind that. She never says, "I closed the churches because of super spreader events. I closed them because of this." She just says they clap hands. And so here we are. She makes a decision. I would hope it was rational. That churches are safer than those institutions, and then she reverses that. And she never explains her rationale for that. We never get a reason. She just says, "I've decided." Fiat from on high, from the executive, without any, and to top it all, and is that we represent at the time 15 million people, and she just doesn't want to talk to us. She refuses to talk to us. Surely she should tell us, "I've changed my mind in such a material way." Surely that's the essence of accountability. We've moved from a system where the executive and the legislature did what they like, where they have a responsibility to all the people. If you're going to make such a decision, then surely you should explain to 15 million people why you've changed your mind, why you're removing their rights away. And so if we look at this matter, my Lord, I would submit that in order for the minister to succeed, she needs to show us why churches are now suddenly more dangerous than restaurants.
I told you that's never been her case. She's never said, she's talked of hugging in that. She talked of more difficult to police, more difficult to regulate. She did do that, but she's never denied that they will spread in casinos and restaurants.
My Lord, my Lord, but that's exactly my point. It has never been her case why she made the change. She's never explained it. Your Lordship is completely correct. She has never given us a proper explanation. That's not her case. Her case, I'm not entirely sure what her case is, but on that very specific issue, She hasn't given us an explanation. There is no case in that regard.
Okay.
So my Lord, I would argue that without a proper explanation for why she picked some winners over some losers, and here I rely on the papers of SANEF, where there were job losses, there were starvations, there were suicides, my Lord. Effectively, income was cut off, and it wasn't for a limited period, my Lord. It was the only reason that the total shutdown stopped is because we were in court the next day.
Is that the only reason?
Well, they haven't explained why else. Why suddenly change? Why do it the night before? Traditionally do it on a Sunday. Suddenly they do it on a Monday. In the absence of an explanation, they could easily have taken the court into their confidence, but they didn't. They haven't come to court and said, this is why we made the decision on Monday night. They haven't given an explanation. They need to take the court into their confidence. My Lord, we are in an era of accountability. We're in an era where they can't hide behind polycentric decisions and refuse to tell us really what they think. They gave us no medical evidence. We asked for medical evidence. We gave them 2 opportunities to do that. They didn't do that. They simply have kept their cards as close to their chest as they possibly could, and they have not. And this is where I must admit I feel hot under the collar. They had an opportunity to come and say, these are our reasons, this is what we relied on. We were totally legitimate in what we did. We thought about this very carefully. We had this medical opinion, that medical opinion. They haven't done that. They've tried to hide behind a veil of confidentiality, which, to be honest, my Lord, in light of the SO decision, is disrespectful to the judiciary and the SCA. So, my Lord, I would argue that in light of SO, instead of trying to debunk it, especially now that it's been confirmed by AfriForum, and if this was a government for the people, where they're happy to receive accountability, what an opportunity to place their case before a senior judge such as yourself. You go through their medical evidence, you go through what they base their decision on, and you say, these guys did a fantastic job, but they have ducked and dived and tried to hide behind mootness. They've avoided accountability at every turn in this matter. In fact, my learned colleague spent about 3 minutes on the justification of the limit and 2 or 3 hours on mootness. The case was procedural in nature. It was their opportunity to come and make a material case dealing with the material issues, and they've simply decided not to take the court into their confidence. My Lord, I would just like to pick up a few things.
I thought you said you're much quicker than your colleague.
My Lord, you said I would never have made such an allegation.
You're quicker than your colleague who's not here.
Yes.
And that was news.
Yes. So, my Lord, if we look at the various issues that have been raised, my Lord, another issue, and your Lordship is well aware that I'm from Port Elizabeth or Gqeberha. This issue, if I can just find it,
find your issue, let Mr. Willis argue, we'll come back. If just people are 2 hours in reply.
My Lord, if I can just if I can just share this page, my Lord, and this goes to the rationality of this decision. This is on 011-265 and paragraph 218. My Lord, when were the total, the complete lockdown was instituted on the 28th of December. And this is very important. Nelson Mandela Bay was first declared a hotspot on the 28th of May, 2020 under level 3. My Lord,
you know that.
They
on Nelson Mandela Bay in answer.
Yes, but my Lord, they then reduced the restriction to level 1 in Nelson Mandela Bay until the second wave had peaked. This is, I would respectfully submit that this is not the actions, rational actions. This is, my Lord, they say they send a team of Cuban doctors in November, 5 months after they declare a hotspot. With respect, I really don't think that we can argue that the minister acted rationally there. And she hasn't approached this matter in a rational manner. And it's because they've approached it in a polycentric manner, selecting winners and losers rather than using the DMA and the authorizations in terms of the DMA to fulfill the terms. I would respectfully submit that they've stretched the DMA beyond breaking point.
Thank you, Crompton.
My Lord,
side yours very much. We're talking about what you did in other things. Mr. Crompton, there's nothing else.
My Lord, there's one other point, is that I just want to raise the issue of foreign law and international law. My Lord, we have a plethora of international and foreign law in our heads, and all of them have dealt with the matter, even though the governments all tried to claim mootness, and they're all lifted or recognized the freedom of religion and the ability and the freedom of churches to meet despite restrictions, and found that any restriction that you cannot absolutely stop someone from worshiping. My Lord, I would be very dismayed if we were an outlier in international and foreign law. My Lord, I'm going to hand over to my colleague, Mr. Willis.
Thank you. Mr. Willis?
Thank you, my Lord.
Yes, the first time I've heard silk come after. So,
my Lord, thank you, my Lord. Lord, can I just ask Mr. Crompton to remove that shared document from the screen, if he would?
Mr. Crompton?
Lord, I would very much like to. I just don't know how.
Very well, I'll proceed.
My Lord, I'll leave and come back. I don't know how to do it.
Mr. Willis?
Yes, my Lord.
What is it? It's the first time I've heard silk come last, and after the juniors have already argued.
My Lord, maybe it's the old adage of mopping up, my Lord. I'm sure you've done a lot of that in your career, my Lord.
Mr. Willis.
Yes, my Lord.
Okay, let me hear what are the points you want to raise, and I want to raise.
Lord, I'm going to lead into costs, deal with costs with your Lordship. Your Lordship's heard me argue costs once before, my Lord, so I know that it's not a matter that's foreign to your Lordship in any event. Lord, I'm just looking for something here that I want to submit to your Lordship that I made some notes on, and now I've lost my notes. If you just...
Well, so on cost, we know that what you call it one cost. We know Solidarity wants their costs. We know
yes,
Mr. Boda doesn't want his costs.
Everybody, Mr. Boda, as is proper and as he ought to have, disclosed to you what their arrangement is with their client. We, the rest of us, my Lord, all seek costs against the state, and I submit properly so. But, my Lord, your Lordship could, of course, even decide the matter without. You could decide it in our favor and not order costs. And that's what I want to guard against, my Lord, in my submissions to your Lordship. My Lord, there is no difference in the debates that have taken place between your Lordship today when it comes to matters of freedom and the sort of debates and arguments that had to be had in the 80s when there was a fight for racial freedom. My Lord, religious freedom is what has been fought about for centuries and probably throughout the history of man. Religious freedom, my Lord, is never moot. Lord, no one thought that this matter was going to take 3 days before your Lordship. Why not, my Lord? Well, simply because on the papers, the issues did not disclose the questions that your Lordship has debated at length with my learned friends for the applicants. My Lord, and that is because, as Mr. Omar correctly emphasized and persisted with your Lordship, that this matter is determined on the pleadings. My Lord, there's a recent matter the Constitutional Court has just decided the last short while in relation to a doctor, a gynecologist, who went to jail. He was sentenced to 5 years. He only did 8 before he was released because it was set aside. It was set aside, my Lord, because the magistrate made findings premised on her own research and her own views and understanding of things. And, my Lord, a man spent 8 months in jail. He's had to now forego he's decided to leave the profession. You would read in this case, I don't have it to hand, my Lord. I think he treated some 40,000 people, delivered 8,000 babies. And then somebody died under his care and he was accused of negligence. And he went to jail because a magistrate failed to exercise her function properly. And I say these things with the greatest of respect to you, because, my Lord, what I appreciate about what your Lordship has done in this matter is you've done something that many of us have learned in our careers from seniors, and that is to test the case. One often sits in your client's case with your attorney, and halfway through the attorney and the client leave, and the client goes outside and complains that this advocate's not on their side. And all that counsel is doing is testing the case and making sure he understands it. Now, to the untrained mind, my Lord, it may look as if your Lordship is not open to persuasion. Of course, we know differently, my Lord. And your Lordship has pressed us and pressed us very hard. The reason your Lordship has pressed us hard is because we were not pressed in the papers or in the heads of argument. Your Lordship is pressed on a very, very important issue, because I know, my Lord, and I trust your Lordship, and I know I've argued matters before your Lordship, and I've argued difficult matters before your Lordship, that your Lordship intends to make the right decision, my Lord. But, my Lord, with the greatest of respect, your Lordship knows that, like that magistrate, you're not an expert in either casinos or in church-going.
Correct.
I know we all go to both, maybe at stages of our lives, but we are not experts in that. The minister's the expert, my Lord. The minister, you've heard the submissions, and this all feeds into costs, my Lord. The minister, I heard your Lordship's debate, and I think it was good and proper that your Lordship pressed, especially the more junior members on this issue. It was good to see them squirm, my Lord. But the minister holds the power. Who she goes to for her assistance, that's her prerogative. But she carries the can at the end of the day, my Lord. She is the expert, my Lord, and we submit your Lordship. She failed to put you in a position to come to the assistance of the state. Even if you want to come to their assistance, my Lord, we submit with respect that you cannot. Now, my Lord, Mr. Omar was correct to argue the words of His Lordship, Mr. Justice Navsa, at page or paragraph 96 of the Liberty Fighters Network judgment. I watched the hearing. I, in fact, acted in one of the earlier parts of that case. And
is it Omar, or is it the court? I thought that was the court's decision.
That was a court decision, but Navsa writes at that stage, my Lord, as I recall. But my lord, and we argued, Mr. Omar and I actually argued that case before the Constitutional Court more recently in the Muslim marriages case, my lord. And it was seminal. It was seminal, my lord, because, and there that was another religious freedom matter. And religion cannot be attacked. It cannot come under attack. We rely on a direct right. We do not rely here on an indirect right. We rely not on a convention. It is a direct right, and it is bolstered all the way down to Section 9 of the Bill of Rights, dignity, my lord. And the matter comes before your lordship.
Section 9 is equality. Section dignity, I think, is number 1. Section 9 is equality, I think. I'm not sure.
Yeah.
Section 9 is
my lord, it goes all the way back down to dignity. And my lord, the point is this. This is not the sort of matter that the minister could afford to come to court on without doing a proper job. Now, in what happened in the Liberty Fighters Network matter that came before Judge Davis initially was the applicants, Liberty Fighters Network and Mr. De Beer, put up a layman's case. My lord, I know those papers. I argued the leave to appeal in that matter. I argued for Liberty Fighters Network. And there, Liberty Fighters Network, we were able to hold down half the case, and the rest of it was given with the Supreme Court of Appeal giving leave. And the reason Judge Davis took the approach he did was because he believed that the minister bore a greater onus, notwithstanding the paucity on the Liberty Fighters Network case. But when it got to the Supreme Court of Appeal, the minister came out on top because the Liberty Fighter Network case, notwithstanding, and I believe that this is correct, I believe this was a tremendous moment for one of our appeal court, our Supreme Court of Appeal, upholding the principle. It matters not whether you come as a layperson or whether you come by legal representation. The standards have to stay the same. And they upheld the appeal, and correctly so. Now, in this case, my lord, the minister gets brought to court on 4 cases, properly established, properly set up. And my lord, with the greatest of respect, my learned friend, Mr. Mokgakabe, a good colleague of mine, he does not take responsibility for these papers, and neither do his predecessors, actually, because at the end of the day, they are purveyors of their instructions. And the case that was put up in answer, my lord, is an insult. It is an insult to the rights of probably the majority of the nation, my lord. And they have not put your lordship in a position to find for them on the basis of your lordship's testing of our case and of their case, my lord. The minister is the expert and she has failed. Now, my learned friend has just argued to your lordship that there's a pattern of this sort of behavior. And this is what brings us to costs, because what the minister did, instead of instructing our learned friends who have valiantly sought to carry out their instructions and make an argument for the minister, but what they've been forced to do, my lord, is to try and squeeze themselves into a case which is not a case, where your lordship has sought to test the cases and test the issues so that your lordship steeps yourself in the issues. And they shouldn't have done that, but they've done that because that was their instruction. And they've tried to squeeze themselves into this case. It doesn't exist on their papers, my lord. Your lordship is bound by these papers, unfortunately for them. Of course, your lordship knows that. I only say it because I must build my argument step by step. So notwithstanding Mr. Mokgakabe's courageous attempt to find a way through the back door into and create a case and hide the weaknesses of the minister's case, my lord, I have to submit with great respect that my other learned colleagues, my learned friends for the applicants, have ably argued and highlighted to your lordship the weaknesses in their case. They cannot be hidden behind Mr. Mokgakabe's valiant efforts to put up your lordship's testing case to your lordship. My lord, she's pitched her case, and like her decision, it comes up short. It doesn't pass muster. It doesn't pass muster in accordance with the rules that we all understand that are applicable in motion court matters. Of course, in motion court matters, your lordship knows, your pleadings is your evidence. She doesn't answer the questions. My lord, she doesn't answer the questions that your lordship poses. So, my lord, in the result, submit to your lordship that your lordship ought to fine for the applicants. And this is one of those matters, my lord, even if your lordship, for some reason in your lordship's mind, wanted to fine for the state and did, for the minister and did, your lordship should still grant us the costs.
I wouldn't want to do that for the sake of it. If she has a case, I will. If
yes,
she's going to lose. Depends on whether she has a case.
Yes, and my lord, I've argued the following before your lordship before. Your lordship knows BioWatch. I just want, my lord, to focus on Harry Lowell's case. You'll recall the words, Harry Lowell's case, my lord.
Harry Lowell's case.
My lord, Harry Lowell's case is, it's 2017. I have the 2017 ZACC 38 as a citation. It may have been reported by now. It's been relied on extensively. And this is what was said in Harry Lowell. It said, although BioWatch was decided 8 years ago, it seems that the other courts are yet to embrace its principle. This is apparent from the growing number of matters that come before this court. This is the Constitutional Court speaking, of course, where the issue of not applying BioWatch is raised. This is unfortunate. In BioWatch, this court laid down a general rule relating to costs in constitutional matters. The rule applies in every constitutional matter involving organs of state. The rule seeks to shield unsuccessful litigants from the obligation of paying costs to the state. The underlying principle is to prevent the chilling effect that adverse cost orders might have on litigants seeking to assert constitutional rights, my lord. So, my lord, if for whatever reason your lordship finds against the applicants, I submit with respect that there is absolutely no basis on which your lordship could order costs against us. My lord, I submit that.
But Mr. Mugabe has conceded that.
My lord,
indeed, he doesn't want cost.
I didn't even hear that concession. My apology for wasting your lordship's time on that, my lord.
From the beginning, right at the end, he said, we asked for it in the heads of argument, but we're not seeking costs at all.
Well, my lord, I only knew what was in the heads. I missed that. My humble apologies. Forgive me for that, my lord. But, my lord, in the result, my lord,
I don't think it's absolutely this question on the cost question. And it's a question I'm going to ask you. It's two-part. If one finds that it is moot, I know there's a strong feeling that it shouldn't be found. And I'm going to be very careful before I make such a finding. But if one finds that it is moot, and you've heard the debate between myself and Mr. Karokia, it happens all the time that parties change at the door of court. It happens all the time. And then the issue becomes, well, then now you've changed last minute, you've compelled me for costs, compelled me to incur costs.
Well, my lord, you could order us the costs, my lord.
Yes, that's what I want to go to. But then, isn't that means that you only get costs up to the date that the regulations change? In other words, up to the date of the Part A application. Because you didn't get that. That wasn't that. Because Lord, after that, the matter became moot. So the court found in their favor after that.
My lord, I hear your lordship. I hear your lordship, and I trust your lordship's not going to come to a finding that the matter is moot. But where your lordship
had the same confidence. I'm going to think very carefully about it.
Where your lordship
I'd like to deal with some of the merits. I'm very tempted to deal with the issues of executive action. I've asked the questions to Mr. Karolia. I hoped someone else would. I should have asked the question to Ms. Engelbrecht, and I'll ask it to you. I've asked that question. Look, how does one distinguish when it's executive and when? Because Mr. Mogachabe urges me not to follow Esau, but to follow Mustert. And I said, if one was to go along that lines, one has to try and do more than just simply say, I accept Mustert. And I tried to ask this question, no, I did ask this question. How does one distinguish an executive action from an administrative action? And the easy answer would be the classical admin decision is taken by the admin person themselves without any other person interfering with or sharing parts of making that decision. Slightly different in executive decisions. They tend to be a little bit more collective, not always, because a decision by a president is clearly an executive on his own, may clearly be an executive decision. So even if he takes it alone, it could still be so. But I've asked that question. I'd love to get into all those issues. But if I find that it's moot, then I'm unfortunately deprived of that benefit opportunity. Is that correct?
My Lord, let me answer just comment on the first question you pose. It is ordinarily, or it is often a vexing question, or it can be a vexing question, whether something is an administrative decision or not, my Lord. But my Lord, it's not that is not something you are truly challenged with in this case. Why, my Lord? Because once again, it is not on the papers. The minister does not come and make that case out, your Lordship. Your Lordship, with respect, has tested the case with that thinking of your own, my Lord. It is not a case with respect.
Look at her case. She says, when she talks about exec action and others,
But my Lord, it's the same in an environmental law matter, where the HOD or the MEC makes a decision. They take into account the evidence and information of experts.
Yes,
but it is not an executive decision.
No, I understand that. I understand that you receive inputs. I gave the example of the pricing committee in the New Creeks matter. And I think the environmental matter, you're probably the one that you said you appeared before me.
That last one I did in front of you, yes.
Legal matter or something.
We're on our way, hopefully, to the Constitutional Court. Then,
I understand. Yes, I understand. You lost in the.
But thank you. But thank you for the results you did give us in that matter, my Lord.
Well, did you win or lose? I'm not sure. But the SCA threw out the appeal. I know that. But let's just stick to our point. So yes, you take advice from a party when you make your decision, but it is your own decision. When somebody else is sitting with you and making that decision as well, or sharing the making of that decision, in other words, not just advising you, but could be the one that takes the decision. In other words, the minister doesn't take this decision alone. It's actually a decision taken by the cabinet.
My Lord,
is that not indicative that it's more than admin action?
I think I can help you with one perfect example on why that thinking that your Lordship is propagating is not correct. And it's this, my Lord. There have been now probably endless number of cases that have been brought against the Crompton minister. Your Lordship will not find one judgment where the NCCC had to be cited. It was cited initially in some of the cases. The NCCC is not a party that has a legal interest in any of these matters. It is only the Crompton minister, and where she takes a decision that might affect another department, they are joined as a matter of caution. But my Lord, there is only one minister in this phase of the history of our constitutional democracy that you're going to run into trouble if you don't join her, and that's the Crompton minister. There are situations where you don't have to join her. I've been in at least 2 cases where we didn't have to join her, even though it was COVID related. But my Lord, if there's justification to join the NCCC, then they would have, because that is
not the NCC, it's the president, isn't it?
Well, no, my lord.
The
No, my lord. Not even the president.
The cabinet decision, she said.
These are not cabinet decisions, my lord, at all.
Well, what was Mr. Mugabe reading then?
My lord, these decisions vest, according to the statute, entirely in the hands of the Crompton minister.
Ms. Engelbrecht, I've noted you. Ms. Engelbrecht, I've noted you.
Thank you very much, my lord. I put up my hand not to interrupt, but as a placeholder, since your lordship said that he ought to have asked me the question, and I wanted to indicate that I would very much like to take up the invitation afterwards
I will ask
to answer that question.
No, I was going to ask you the question anyway.
Yes.
Okay.
But I will wait
Willis?
until Mr. Willis has completed his address.
Mr. Willis?
So, my lord, the authority vests in the Crompton minister. This is not a matter, my lord, where where this power is shared, or she could. In fact, I'm not even certain she can even delegate, my lord. I haven't applied my mind to that. These are her decisions. She might take them under advisement. In fact, she ought to. And this is part of the problem in this case. She puts up no evidence to show you, my lord, scientifically, and the courts have spoken to the science repeatedly on these cases, to show you, my lord, why clapping is an issue, or why churches are an issue, my lord. This whole economic argument that your lordship has tested with and proffered, respect.
Mr. Willis? Mr. Willis, can anyone hear me?
Yes, Judge, we can hear you.
Yes, my lord.
Mr. Willis?
Can hear you, my lord.
Can you hear me, my lord?
Yes, now.
Am I back? So, my lord, just to repeat that, it's part of the problem in this case, is that this argument around economical interests, such as your lordship has put the questions, has not been fleshed out in the minister's case. And had she done so in her papers, my lord, there would be scientific evidence. Her decision is irrational because
what scientific evidence would there be?
My lord, sorry?
What scientific evidence?
Well, my lord, she notionally tells your lordship or mentions, and that's the high level mark of her case, that people clap in church. Well, people clap in a lot of places. People drink alcohol in casinos. Now, my lord, where is the scientific evidence to demonstrate to your lordship, or the sociological evidence to demonstrate that churchgoers are less worthy of their rights than economy? I mean, are we going to get into a debate between the poor and the wealthy? So, my lord, with the greatest of respect, that's the problem in this case, is the lack of evidence, because I submit, your lordship, on the probabilities, and one doesn't measure this evidence on probabilities, but in as much as you want to consider the possible answers, if there was evidence, she would have put it up. If she did take this decision in a collection of people, she would have put it up. My lord, this is an administrative decision. By no stretch of the imagination is it executive, my lord. I submit with respect, and it's good that your lordship tests it, but that is a ruse of an argument by the state, my lord, that this, just like the moot argument is, as has been submitted to your lordship. Lord, I don't have too much else to say, save, of course, anything your lordship might ask of.
Nothing. I want to give the floor to Ms. Engelbrecht.
Indeed so.
Ms. Engelbrecht.
Thank you, my lord.
As it pleases the court, I won't take long in answering the question that
One
your
thing
lordship
I must say, you've never taken long. You've been succinct always, Ms. Engelbrecht.
Lord, the starting point of answering the question about whether this is administrative action is section 27.1 and 27.2 of the Disaster Management Act, because that is the source of the power of the minister. And we see in 27.1 that in the event of a national disaster, the minister may, by notice in the Gazette, declare a national state of disaster, and the circumstances in which she may do so are set out. In other words, she is not given a wide discretion. She has to only do that within the circumstances contemplated in 27.1a or b. And then 27.2 says, if a national state of disaster has been declared in terms of that subsection, the minister may, subject to subsection 3, and after consulting the responsible cabinet member, make regulations or issue directions or authorize the issue of directions concerning, and then there's a variety of matters. Now we know that the minister here is the responsible minister, is the Khokhta minister. That's the minister that's been delegated with this particular authority. But what the section makes absolutely clear is that she issues these regulations or directions after consulting the responsible cabinet minister. So, for example, the DTI minister in relation to something concerning trade and industry and the like. But we know, and your lordship will be well aware of the case precedent concerning interpretation of what is the duty after consultation, in consultation with, etc. Here, what is required is that there may be consultation, but the ultimate decision made here is the only responsible person, in terms of the clear language of the statute, is the minister herself. She is the one that takes the decision, and she takes decisions that in paragraphs, I think it's 33 to 35 of the AfriForum judgment in the Supreme Court of Appeal, 33 to 34, makes it very clear that this decision-making is it's a bureaucratic process. It's the minutiae of how we regulate, the minutiae of how we decide. It's not simply a matter of making a policy decision that there should be restrictions. What is being done is that delegated legislation is being passed to give effect to the policy after consultation with the cabinet minister. It is now bureaucratic. And I must make this point. From the line of cases that starts with Harris, the education case, and which is confirmed in the AfriForum case, when a minister or a party invokes a power that it has in a general sense in order to justify that which it has done, although previously it invoked another section, that's not a proper justification. The bottom line is this: if the minister here has gone beyond her powers, under 27.2, she's ultra vires and therefore can also not justify. So either she must accept that this is administrative action that is governed by 27.2, or she falls short because she wants to rely on a broader power than the bureaucratic powers that were afforded her under the Disaster Management Act. Those are our submissions in that regard.
Thank you. Thank you. Thank you. Ms. Martins, is there anything you want to say on this issue?
No, thank you very much, my lord. I think it's been well captured. Thank you so much.
Does everyone agree that if there's a finding of mootness, I'm not sure it's going to be taken so lightly, but assuming there is, then one avoids answer. One no longer has to deal with the rest of the case. That was Mr. Mokgekgabe's submission. Is that right, Ms. Engelbrecht?
My lord, if I may say this, it is of course in principle correct that if the court can dispose of the matter by adjudicating it on a single point, it is open to the court to do this.
But there is strong authority, particularly you see a lot from Innes and you see it by Corbett and others who say, please don't go any further.
Yes.
There's a long authority, and that's what he meant by cadet question.
Yes. But there are also indications in a later and more constitutional era that it might be of a benefit. In this case, what your lordship is faced with, and is what your lordship recognizes, is there are important matters relating to whether it's executive action or administrative action and the fundamental right to religion. And for example, in the case like I want to call it the master's policy case that concerned, it came before his lordship, Mr. Acting Judge, Justice Katz in the Western Cape High Court about the allocation of insolvency practitioners according to race. and the matter went through the Supreme Court of Appeal and ultimately to the Constitutional Court. And in a matter like that, His Lordship, Mr. Acting Justice Katz, recognized that even though the matter could be disposed of on one point, in a matter where the expectation was that higher courts might be called upon to adjudicate on the matter in due course, it was helpful that all of the arguments that were presented were dealt with in the matter so that the higher courts could engage with those findings in addition to as it were, the main point. So we would submit that Your Lordship might be guided by that, although it is open to Your Lordship to make a finding on a single issue here. The expectation that the matter will go further, given the importance of the case, suggests that Your Lordship should engage with all of the arguments that have been placed before you, so that any court that might consider the case in due course has the guidance of the thinking.
Yes, thank you. Thank you all. Thank you. Is there anybody who wants to say anything? Is there nobody who wishes to say anything? Well, in that case, judgment is reserved.
Sorry, my Lord. Might I, on behalf of the applicants as well as the respondents, thank Your Lordship for your patience over the last 3 days. We're indebted to Your Lordship. Thank you, my Lord.
Thank you. Thank you. If there's no one else who wishes to say
well,
anything.
my Lord, I want to say that also convey the legal team's appreciation in dealing with the matter, particularly in giving the applicant's counsel more latitude in reply to ventilate matters which in practice and in terms of the rules they were not supposed to. They started to rehearse their case, my Lord, but we appreciate that, my Lord. You have given them more than sufficient opportunity and time, my Lord, to ventilate their case. And we laud you for that, my Lord. And we thank you for conducting the case and having to bear with us, my Lord, and bombard you with so much information for 3 days. But we all say, my Lord, we handle the matter well, my Lord, and that that's it, my Lord.
Thank you.
Even there's something I want to say, my Lord. I trust that Mr. Willis, as a senior counsel, when he made that submission, that in the presentation of my case, I did my valiant best to hide the weaknesses of the respondent's case, that he was not impugning my integrity or casting aspersion on my dignity and integrity and character.
Thank you.
Absolutely. Lord, might I assure both you and Mr. Mokgakabi, absolutely not.
I know that. I know that. Thank you.
It is his skillfulness to which I allude, and by no stretch of the imagination would I ever cross that. He couldn't accept that from me. Thank you, my Lord. Thank you, Mr. Mokgakabi.
Thank you.
Thank you, my Lord. Thank you.
Nothing else?
Nothing, my Lord.
Thank you. Then judgment is reserved and court is adjourned.